Color agenda. We are going to now call this meeting to order and ask for a roll call by our city clerk.
Councilmember Cardenas?
Present.
Councilmember Jackson?
Here.
Councilmember Silva?
Present.
Mayor Pro Tem Garcia?
Present.
And Mayor Vegas-Walker.
Here. If you could all please stand and join Mr. Garcia as he leads us through the Pledge of Allegiance and then remain standing for the invocation.
Ready? Begin.
If you could remain standing and bow your heads, please. Heavenly Father, we come before you this evening asking for your comfort. This community has suffered some very dear losses in the last couple of weeks, and we know that there's several families that are grieving for loved ones that were taken much too soon. Please pour out your mercy upon these families. Touch their hearts. Let them know that they have the surrounding love and commitment of their neighbors. We hope will strengthen and comfort them in these difficult times. Help us to be mindful of the needs of others. Help us to always do what's best in thy sight and for our community. And these things we pray in thy precious name. Amen.
Amen.
Okay, we did meet in closed session. Starting at 5:15, we'll have a report out on closed session by our city attorney.
There's no reportable action, Madam Mayor.
Moving forward, the only item on our agenda tonight is a request of an appeal by the Certified Water and Wastewater Treatment Plant Operators Bargaining Unit of final determination regarding composition of the unit. Now, I've got 3 speakers slips so far. If you want to speak to this item, please either give, correct way would be to give it to our city clerk, Diane, Ms. Caldwell, and then they get passed over to me. So what we're going to do is have the item introduced by our city attorney, and then we'll decide who wants to, oh, these are numbered in order of appearance. You guys are really good. All right, so then we'll call these up in order of appearance, and then anyone else who wants to speak to this item, and then the city attorney will lead us through a presentation.
Madam Mayor, I just have a quick comment. I do have to excuse myself at 6:45 today.
There's no excuse for you.
Sorry.
Okay, we'll try to stay on task here. Okay,
Madam Mayor, on behalf of the city manager and staff, and as an aid to both parties, we have prepared a timeline of the events here, which are important given the nature of the appeal. This is an appeal regarding process and a question of whether the ERO's determination followed the right process. You'll see the timeline in the beginning of your packet. The documents which correspond to the timeline are included in the packet, as well as those documents provided by the certified water and wastewater operators. We have a PowerPoint presentation for you to provide you an outline of the law and the steps that the ERO took, but given the fact that Councilmember Cardenas needs to leave and the fact that often the appellant goes first, I wonder if you would like to hear from them first.
right, and I think we want to be really careful with our use of acronyms. We could acronym ourselves to death tonight. So ERO.
I'm sorry, the city manager is the ERO.
And that stands for Employee Relations
Relations
Officer.
Officer.
Who
Yes,
has
ma'am.
the role in this. Okay, so let's go ahead and start with Marcos.
And Madam Mayor, one point. You do have an additional document provided by the Certified Water Distribution Operator's attorney. It is a redacted letter that was provided by the city clerk about 4:30 this afternoon. And it looks like this.
This is the most redacted letter I've ever seen.
Agreed, but it is here for your consideration.
Okay, let me take 1 minute to read this,
It's
please.
like going through an FBI file.
Or your
Did you all
file.
get a copy of this? Did you get this? Did you receive it? Yes? Okay.
Okay, all righty. Okay, so, Terrazone, and Mr. Terrazone, followed by Mr. Salas, followed by Mr. Flores. Very good. All right, floor is yours.
Good evening.
Mayor and City Council. I'm Marcos Tarazon. I'm a negotiator for the Certified Water Wastewater Treatment Plant Operators Bargaining Unit. These are my fellow negotiators, Jose, Ramiro, and Mario.
Mhm.
So the reason why we're here tonight is just to point out a couple of procedures that were skipped, we believe, by the ERO, City Manager Marcela Piedra. And I was hoping that we went through the timeline first, but that's okay. I'll just get to our points.
We can
Would
pop
you
up
like
the
us to put
timeline
it up
of-
for you?
with
Sure,
the-
I guess the first,
We do have the timeline in front of us while this is coming up, so if you
am I
want to let
restricted
us
to
know.
3 minutes or no?
I'm sorry, what?
Am I restricted to the 3-minute?
Well, we don't want you guys to, first and foremost, if you would make your points and then not repeat.
Okay,
Okay,
perfect.
ready, go.
Okay,
Go to the packet.
I guess my
like
point is,
this.
are you looking at this timeline?
Yeah.
Because that's in front of us right now.
okay. So that first box, I guess,
Ours starts with March 7th. Is that what
Correct.
you're looking at?
March
Okay.
7th. So this timeline helps a lot because it gives us a lot of insight too on how we eventually got here.
Okay.
And we were aware of the beginning of these timeline events. But there is a date here, March 7th, that's dated, and this event did happen here, where I'm gonna refer the other group, the CWDO.
Right,
That's the 9 members that are joining our group, or
Right.
are in our group. So I'm gonna refer them as to CWDO. So that's when they indicated that they wanted to be part of our group's
Right.
Certified Water Wastewater Treatment Plant Operators.
yes.
And that was in March 4th. Obviously, we weren't aware of this. We weren't aware of this until July 31st.
Okay.
And that's an important date for us because, well, we get to that later. But we want to stress out that we weren't aware of this till July 31st,
And why is that important, that you weren't aware, that they wanted to be invited?
because that's the basis of our appeal. As we get, so I'll get to I'll get to that eventually, but when we got to this meeting on July 31st, I want to point out the invitation that was sent out to us by Claro Beso, and we all have the packet, right?
Yep.
So,
The timeline included in the agenda packet. Right, that's what we're referring to, okay. So I'm looking at page 4. The bottom of page 4 of the agenda packet has the July 31 date.
okay, let's go to page 61. That's attachment 3 of our appeal.
Okay, let's make sure we're on the same, okay, my page 64 is attachment number 3. Says pre-bargaining meeting, water, wastewater treatment plant operators. Is that what you're referring to?
That's correct, yeah.
Okay,
So the subject line, you pretty much read it there, and it's titled pre-bargaining meeting. So as we approached this meeting, we approached it as if it was a negotiating meeting. So we came prepared to negotiate. Obviously, the informal topic of the 9 members joining our group got brought up. So they asked for our comments. Marcela, Abraham asked for our comments, and they request, and we try to give the best comments that we had, but obviously we weren't unprepared. So when I mentioned on my appeal, spur of the moment comments, that's the way they were. They were spur of the moment. They were at that time. Later on, we obviously thought we could have told them this, could have told them that, could have elaborated or articulated better our comments, but that wasn't the case at that meeting. So we gave the best comments that we could have.
okay,
And unfortunately, those were the first comments that the ERO heard from us and the last comments that she heard from us. So she told us too that, Marcel told us too that these comments were going to affect her final decision. A decision wasn't made at that meeting. So that was the July 31st meeting when we first got aware of the 9 members that were going to possibly join our group. So After that meeting, obviously negotiations started. We had our first meeting the day after, August 1st. We met with Dave Ritchie and us four, and we negotiated. Outside the meeting, before the meeting actually started, Dave Ritchie approached us and he asked us, hey, what do you guys think about the 9 members joining your group? So we didn't want to comment too much, but we said, you know what, we'll take this back to our group. We'll discuss it with the rest of the members and see what they think about. So we had that first meeting, August 1st, negotiating meeting. Then we had another meeting, August 16th. And at this meeting, which the timeline that the attorney was going to present to you guys doesn't talk about this, but that second meeting on August 16th, the attorney mentioned that this was a dead topic. Don't worry about
And which attorney are you referencing?
Dave Ritchie.
Okay.
So he mentioned that this was a dead topic. Don't worry about it. The 9 members are not going to be joining your group this go round. So I'm like, okay, let's continue on negotiating. So we continued the negotiations. We had another meeting August 23rd.
Can I pause you for just
Sure.
1 minute? So Mr. Ritchie obviously isn't here to either collaborate or dispute that statement.
That is not my understanding, but I was not at the meeting.
Okay, I want to kind of whiteboard that for a minute, because I think that different information was conveyed back to us with regard to the outcome of that conversation, but, okay,
Okay.
you can continue, please.
So yeah, we had a meeting August 16th, August 23rd.
Mhm.
We were continuing negotiating, and there was another scheduled meeting for September 6th. That meeting got canceled because there was a September 4th meeting 2 days before that.
Okay.
And I'm going to try to explain how this meeting took place. There was a lot of confusion going on before we headed to this meeting, and we started to see a pattern getting into his meetings with the ERO and the Public Works Director. A lot of confusion was going on. We originally thought it was going to be a telephone-in conference meeting, and so I think I called Clara to find out, okay, well, where do I call? She said, no, you guys got to be here at the meeting. Okay, so I tried to call everybody up. You know what? It's a mandatory meeting. We got to be here. So the other thing I want to point out on that same attachment 3, page 62 on your packet. The subject line to that meeting was mandatory labor negotiation meeting. Again, eventually we saw this as misleading. And we try to figure out, well, so anyways, we get to the meeting, and the invitation's on there too, on that attachment 3. It's only myself and the rest of the negotiators, and city manager and Dave Ritchie were the only ones that's supposed to be there. We got there, obviously that wasn't the case. There was supposed to be a representative from the CWDO group and their attorney. So they weren't there either. And that's the redacted letter that you guys have now that collaborates the kind of the, I don't want to say the unpreparedness for this meeting, I guess. That third sentence, I could read it to you guys, or you guys could read it. It says, my apologies for missing, this is the attorney for the Undergrounds group. My apologies for missing the September 4th meeting, as I was not given accurate information regarding the time that it was scheduled to take place, nor I was aware of the agenda or the fact that the members of the CWWTPO-BU would be present. That's our group. So obviously we didn't know they were gonna be there. They didn't know that we were gonna be there. So a lot of confusion going on, obviously, right? So this was an email that they sent us a few days later. And that's the reason why I turned this in, just to prove that there was a lot of confusion going on. So, and as we got to the meeting, I think Manuel was supposed to be there to represent the Undergrounds group. He wasn't there, he was off on training. So it was obvious that he didn't get the memo, or You know, this was an important meeting for them, obviously. And the attorney that represents them was gonna telephone in, and obviously they tried several phone calls, they couldn't get a hold of him, so he was not there. So they called their backup, Matt, he showed up, and we had the meeting. That's when we got the September 4th letter, pretty much saying that the 9 members are gonna be joining our group.
Okay,
So we get to that point. Obviously, we're a little bit of kind of upset. And I think in the meeting we mentioned they wanted our comments in that meeting, and we reserved our comments. But we did mention the unprofessionalism and the unpreparedness towards these meetings. We were kind of upset how these meetings were taking place, misleading. The subject headlines had nothing to do with the unit modification.
so can I ask you a question? So
Sure.
when you received, Ms. Obeso sent this email out on Wednesday, August 29th, letting you know that the following Tuesday, September 4th, there would be a meeting at 9:15.
Correct.
Did you email back and ask for any kind of clarification? Did you say, hey, who all should come? This says that it's a mandatory labor negotiation meeting. What's going to be the scope, or?
No, I never called to request further
clarification.
information.
Okay,
Yeah.
all right.
So yeah, so that was that meeting for September 4th, where we got the letter, which basically determined the 9 members were gonna join the
Okay.
Certified Wastewater Treatment Plant Operators Group. And obviously, we're in the middle of negotiations at this point, and so that was gonna definitely put a stall to it, because now we're adding another group with their own agendas and their own negotiations request. So now we get, there's obviously a lot of emotions going on here. We're kind of upset how things are taking place. And eventually we start digging information, and we run into the resolution 0271. Okay. Trying to find my spot here. So as we started reading through this resolution, we see that there's certain steps that need to be taken, and that's, we kind of try to break it down in our appeal letter to the council, to you guys.
Is there a page reference that you're
Yeah,
looking at
we
right
could
now?
look at page 39 on the packet, under discussion.
Okay.
And I'll just basically read it. It's pretty self-explanatory, I think. But if there's any questions, just go ahead and stop me, and I'll try to.
I think, I'm going to stop you there just in the interest of time, because all of us have had this packet now for several days, and we've all had a chance to read it and highlight it and know
Okay.
exactly where you're going. So what I'm going to ask you to do is kind of sum up your concerns.
Okay, so yeah, that's what I was getting at. So these are
Okay.
the main 2 points where I kind of
Okay.
want to
Okay,
get to.
perfect.
And so, again, I'll just read it. Section 11 specifically sets out the procedures the ERO must follow when modifying and establishing unit. First, the ERO shall give a written notice of any proposed modifications to any affected employee organization. Section 11 also gives direction as to when this written proposal must be delivered. Points to the periods specified in Section 7 of the EER. The open period specified in the first paragraph of this Section 7 is during the month of March of any year. After written notification is given during the open period, Section 11 then directs the ERO to hold a meeting concerning the proposed modifications, at which the time of all affected employees' organizations shall be heard. So these are just the basic procedural steps that must be followed during any type of unit modification. Obviously, there was no written letter given to any of us negotiators or to any of our groups. And obviously, there was no meeting held to meet and confer over this letter. So, and that's what our group is just trying to establish, go back to these resolution that the city adopted back in 2002 of July. that sets the ground rules for the employees and employer. And we want to build that trust as we move forward during these negotiations. Obviously, it's a difficult time for everybody. Everybody has their own agendas. Everybody wants to get this and that, and we're trying to get through this as soon as possible. So, and when this happens, it causes a lot of more confusion and extra tension that we don't need. So that's all we're asking for is that we continue to follow the rules that are set in the resolution 0271, and we respectfully request that the City Council find that the ERO did not follow the notice procedures required under Section 11 for the unit modification. And then our group also respectfully requests that the ERO final determination be held invalid and to be set aside. I don't think I missed anything else. Any questions?
I'm going to defer to my colleagues here for a minute, see if, any questions?
I'm going to
Ms.
defer,
Weinberg?
personally, I'm going to
Wait.
defer to all comments. And
Okay.
then-
All right, okay, thank you. Mr. Salas, did you have something additional to add, separate and apart from what we've heard so far?
Yeah, well, I will try to resume what he said. It's just 5 items, very quick, shortly. It's, Ken?
Okay.
Good afternoon. I'm Ramiro Salas. I'm work at the water treatment plant, part of the negotiation group. And we handed out several copies to you. It's the summary of rules and regs of employer and employee relations, as well as a petition dated on March 31st, in which I'm going to call the underground people, because we usually call them in that way, water distribution operators. And one more letter dated April 28, 2011. It was a unit modification in which we actually are informed that we received some employees from the underground people into our unit. And one more letter dated May 5th, 2014, which is another unit modification request from the same underground people or group. Okay, so basically, first of all, what I would like to talk about is the facts in between the process. We met July 31st on regards this issue. The subject at that time was it wasn't labor negotiations, but was pre-bargaining.
Okay, and remember our first request that in the interest of time, if you have something in addition to add, so we appreciate that that the additional information, the new information that you've provided to us is calling our attention to these documents.
Yes.
But what I don't want you to do is to please repeat
All
what-
this information is going to be related to that. So we have just 2 meetings, July 31st and September the 4th. On July 31st, we met with the city manager. We met with the city engineer, public works director, and we were asked to give our thoughts about what we think on unit modification if we wanted to receive some underground people into our bargaining unit. At the time, we never received any written information. It's just basically a verbal, everything was verbal. We never received a petition, a request from the underground people. And so basically, we never received what you have on your hands the memo dated on March 31st, 2011, in which some of the underground people request the petition to a modification of our unit in order to be accepted into our group. So yeah, they are listed. They were 4 at the time, and we didn't have any inconvenience on at that time. So at this time, we never received any kind of petition on that issue. So that regards also on the summary of rules and regulations of employer and employee relations described on section 7, which is stated that the petition may be filed with the ERO only during the month of March. It's so-called the open period. It also is also mentioned on section 9, unit modification, which stated that modifications of established appropriate units may be considered by the ERO only during the open period, which is the March of every year, and submit recognition petitions. So we never receive a petition for that issue. At the same time, we never receive the granting notification from the unit modification from the ERO. And something else is that we never hold a meeting with all the parties involved. So those are the procedures that must be followed based on this regulation. If any group, any bargaining unit wants to be or request to be modified or whatever, needs to be requested a petition during the month of March of every year. So it never happened. So that's why into the package that you have, you are not going to see the petition because it doesn't exist. There is a petition in which the underground people request to be decertified from the Teamsters group.
And
But-
can I stop you there?
Yeah.
Because I think that's a really key date. So that letter actually wasn't received until April. Correct?
Which one?
Correct.
The letter with regard to the Teamsters wasn't received until April.
There was
So-
an informal letter at the end of March. There was a formal letter and the Teamsters letter within the first week of April.
Okay, but the point is that with regard to section 7 and some of these other things that talk about a March deadline, the March deadline could not have been met
Correct.
because this didn't occur until April.
In addition, the March deadline does not apply to an independent determination by the ERO.
Okay, all right.
Okay, I just wanted to prove that we never received that request. We never was informed of that request because it didn't exist. Now, something else is the second letter on March 31st, 2011, we didn't have any issue on receive those underground people into our group. So that's why on the memo dated April 28, 2011, at that time, the city manager, Ruben Duran, is give us or sending a memo, give us the thanks for the cooperation of accepting those people into our unit.
Okay.
Now, the last part, it's is regards with section 8 of the rules or the procedures that needs to be followed. The section 8, it states that policy standards for the determination of appropriate units, and within those standards, it's coming the history of representation in the city and similar employment and consistency with organizational patterns of city. So You have also a letter dated May 5th, 2014, in which it's another unit modification request had been done for the same underground people or underground group in order to be transferred from our group, from the water treatment plant group, getting back to the Teamsters Local 542. So at the time, we didn't have any object, so we didn't contest. On the second page of that letter, at the center, there are paragraphs stating that the water treatment plant operators unit indicated they will not contest the request to transfer from their unit to the Teamsters. So all of this is just to tell you that about history of representation and consistency from those underground people or group. So from the term of 2011, 2012, they were, or they belong to our bargaining unit. We didn't have any issue on accept them into our group. But later on, 2 years later, they request by their own to leave the group, and we didn't have any issue in that. So right now, we are coming back with the same issue, and but this time there's no petition, there's no request, there's no letter from the underground group dated on March stated any petition for that.
Okay,
So that's
right.
basically what I have to say.
great, thank you. Okay, Mr. Flores. And again, kind of the same,
I'll keep it short.
keep
Since-
it brief.
Yes, good evening already, Mayor and council member. There's not much more I can add to what my counterparts have already established. It's very well aware, you guys are very well aware that our issue is the timeline. And I just want to take a minute to thank you guys for letting us come here and talk to you guys. And for most of us, it's our first time being in front of our council for our city, so thank you for that. Secondly, one of the key items for us is that, and we feel as fellow city employees, we welcome everybody into our group. We have no issues, we have no animosity against any other group. The only thing that when we talk to our group, if you look at the timeline on March 7th, when initially it was brought up for the underground or distribution operators to come to our group, it clearly states that they indicated their preference to be part of the certified water and wastewater. Now, Ramiro has showed a history of how whenever a group wants to move over to another group, they follow the March timeline. I don't believe that it was that difficult to let us know, hey, these guys want to join your group, here's a letter, something like that, inform us, because now we're already in the month of October. We haven't even had a chance to properly negotiate because unit modification has been brought up almost in every single meeting. We don't feel like we've had a good negotiating meeting till this day, because unit modification has always been looming in the background, you could call it.
Okay. Can I ask the three presenters, I think what I've heard, I think what we've heard is that it's the procedural issues that you're talking to us about, right? I've not heard any of you dispute that there's a shared community of interest, that both groups, the duties and responsibilities of what you do, there is a shared community of interest. So it's the procedural stuff that's in front of us, right? Okay. All right, did you have anything else that you want to share
No,
with us?
just
Okay.
that we're really trying to move forward with our negotiations.
Right.
And we really just want to make it easier on everybody. We want to make a nuisance for the council or for our new negotiators, whoever they may be. But this is something that's just been holding us back
Right.
from moving forward.
Yeah, we're gonna get off that center point tonight. So, is there anybody else that wanted to speak to this item before we come back? you guys want to talk? Okay, thank you very much.
Thank you very much.
Okay, then I think we're going to go ahead and power up the city attorney's presentation.
Where you going? Gotta pick up my wife.
Advance it, or do you want us to advance, or you want?
No, no, I'm good.
You let me know when?
My wife can wait at the
Okay, I
bus
can
stop.
do it.
But she has a bus stop. I call one of my patrol guys to pick her up if she's at the bus stop.
Okay,
Madam Mayor and council members, we put together, as you know, the timeline to try to assist us here, but first, let me give you a little bit of background and response, not in an argumentative manner at all, to what was presented here. We agree with Mr. Flores that this has held up their bargaining, which is one of the reasons we hope we can find a way to move forward. We understand that they do not want the underground guys in their group, and we understand, I think, why.
I'm not sure I heard that.
Yeah, I
I'm
didn't
seeing
hear
a lot
that.
of heads shaking now.
We understand there is a concern. Is that better? Okay, sorry about that. Okay, we understand there is a concern, and I think we may understand why, but there is a community of interest. During the time after the petition was received in March informally, and through April, as you may recall, the underground operators approached the council and asked what would happen to them. At that point in time, we believed they would be going into the general unit, which is where the remainder of the Teamsters unit was placed. Unfortunately, they objected rather strongly to that, and so that negotiations could go forward with the general unit, which has 95 people, they were not placed in the 95, with those 95 people, leaving them in a kind of limbo that had to be resolved. After discussions with a variety of people, this was the resolution. We can go quickly through the timeline and,
You want to go through the timeline?
yeah, go ahead. So we've all talked about the background. We agree about the background. Can go to the next slide. The ERO in this case, under your resolution 0271, has the authority to determine the unit. Otherwise, it would fall under Myers-Milius-Brown, but you have adopted your own employer-employee relations unit. So what has to happen before she makes a final determination is that the public agency and the units affected have to meet and consult or confer in good faith. We believe that's happened here for a variety of reasons. Go on. We talked about this resolution. We agree with the presentation that this does govern the situation, and we agree that the sections that govern it are sections 11 and 12, which talk about the unit determination by the ERO and the appeal. We don't agree that section 7 applies here. You don't need a petition for the ERO to make a determination. One of the powers that she has is to make a determination on her own as the person who has the ability to determine the unit. Go on.
Can you restate again, Ms. Betsy, why section 7 does not apply?
Section 7 applies to a decertification petition, such as the one you had here, such as the one they gave you the documents about in 2011 and 2014, where a unit says, I don't want to be part of something anymore. For example, the underground guys said, we don't want to be part of the Teamsters unit anymore. The situation got complicated when the Teamsters then quit, but that's how it begins. If you look at the second or third sentence of Resolution 0271, Section 11, it tells you that the Employee Relations Officer on her own may make a unit adjustment at any time. And we agree that the language of the first 2 or 3 sentences of Resolution 0271 are confusing. One says, oh, go back and look at Section 7. The other one says you don't have to. Because of the nature of this, we chose the one that says you don't have to. We think that, among other things, needs to be clarified in this resolution. But for our purposes, we don't believe Section 7 governance because the language of Section 11 says you may make this determination anytime, which makes sense because otherwise you couldn't make a unit determination to allow bargaining to go forward. You'd have a unit who sat in limbo, again, for an entire bargaining season. I think the mayor pointed that out earlier. So we all agree that the group here did not appeal the unit determination, just the process followed, and so we'll talk a little about the process. They did in fact meet in July. It was intended to be a non-threatening meeting to try to get their input. For that reason, there was no formal letter sent. It was a, is this going to work out kind of meeting. There was follow-up discussions. It's my understanding from talking with Dave Ritchie that he talked with them about the ability to use impasse procedures in the event that a unit composed of both groups was not working for their needs in getting their bargaining and what they needed to bargain. You go on to the next slide. And you can go, I've told you all this already. I think I might have memorized this by now, so you can, okay. In a way, what happened here is that they were actually given quite a bit of due process and meeting and conferring, but it was done, I guess, you could almost call it backwards. They had a meeting before they had the final meeting for unit determination, and whatever their understanding may have been, the September 4th meeting included both groups. It was noticed almost a week ahead of time, and it included formal letters with clear background, separate letters to each group, dated September 4th, they're in your packet, which talked about this is why this determination is being made, here is how you appeal it, and we provided copies of the employer-employee resolution. They did appeal in a timely manner, but I do want to point out one more thing. Throughout this process and in the letters that you will see back and forth between them, the ERO has offered repeatedly to meet. There was not a request to meet again to try to work this out. We simply proceeded to appeal. I don't think that necessarily another meeting will be helpful here because I think we're going to come to the same place. So I'm hoping that there can be a way in which in this process, in the same unit but perhaps separated, we could work with these two groups together to get them through this year because they're right. Particularly the underground guys have not gotten to bargain so far, and we're almost a resolution with your other groups. Let me see, I think that probably, unless you would like to hear from the ERO, covers it if you have questions.
Madam Mayor, can I just ask Ms. Betsy again to restate what she believes would be an appropriate resolution to this? Just one more time, ma'am.
I'm trying to be creative and to try to say, okay, you have two sides here that are opposed, and maybe we can try for a period of time to meet in the middle so that we can begin to have a constructive conversation. Perhaps there's a manner, and I think the council should talk about this, that you could have a bargaining process where they were in the same unit for now, but the negotiations were conducted separately. Their interests would come together in their MOU. Something like this has occurred for the general unit with some of the others transferred from the Teamsters. The dispatchers had a form of not separate in terms of being in the room, and I'm proposing separate in terms of being in the room, but separate in terms of their interest, and there's a separate section in the MOU that addresses that. But that's an idea for your consideration that has not been brought up to either group.
Okay.
Being that you brought that up, and I don't know, obviously you guys don't have a whole lot of time to think about this, but is that something that would be acceptable to both groups so that we could move this bargaining forward?
Does anybody need to hear that again, what we're kind of proposing? Okay, so, and that's why we wanted to kind of make sure that we fully understood what the appeal was about and what the issues were. And it sounds like a lot of the issue has to do with when were you told what you were told and the procedural issues that followed thereafter. And then also the fact that we're kind of we're stalled with regard to negotiations while we sort through the procedural process. What's being proposed is that we move forward with negotiations ASAP, separately, but still under the umbrella of a combined bargaining unit. That way, each group has an opportunity to fully disclose, fully talk about, vet, have negotiated their specific issues that they feel are unique and of importance to their group, and then bring those back together under a unified umbrella into a single MOU.
Yeah,
That's what I'm
and
hearing.
We appreciate those ideas, but again, I think we're governed under this resolution for a reason. So as we get to these meetings, we have an understanding of what we're going to talk about. We have an understanding of what comments we're going to make. We could elaborate and articulate our answers a whole lot better than spur of the moment comments.
So if we do a better job
Exactly.
of agendizing the meetings,
Yes.
letting you know who's invited, what the expectations are, is this something that you would entertain?
Oh, obviously, yeah.
Okay, so then can I get a representative from our other group? So you heard that what's being proposed is kind of like couples counseling, where we put you into separate rooms
Right.
and we talk about things and then we bring you together and everybody
I have the
moves on.
scars to prove you. Yeah.
What do you think? I mean,
If
Can we
I
do
hear it
this?
correctly, there was something in the back of my mind that I hoped would have been proposed tonight. I do agree with the city as far as we do share, similar.
here's the
everything.
buzzwords: shared community of interest.
Shared community of interest, and I agree with that. And just for the record, for us, our original Plan A for the distribution operators was to become our own unit. Now, I know we don't work on space shuttles, and we don't have any job duties that are out of this world that would qualify us. But our compromise was to join with the wastewater and treatment bargaining unit. And there was a special or a city council meeting where I remember you had proposed a little special carve out because of the complexity of where we're at as a unit. And the last thing in my mind is to hinder or keep any unit, whether it be the general wastewater treatment operator bargaining unit, from coming to a resolution in a timely manner. And that was never my intention.
Right.
It was always been my intention to come to the table and to negotiate in good faith, in hopes that we could come to, to be a part of a unit that I believe we're most like.
Right.
And so if I do understand it correctly, we would be continuing with this unit, but we would be doing it separately as far as.
You would have your own opportunity to talk about your issues,
Separate
And-
from their
separate
Their
from
group.
there.
And
So,
I'm really happy about that, so.
Ms. Caldwell, do you need a speaker slip from him, or could you submit the blue sheet so she can keep track of your
Sure.
comments?
Sure.
Thank you. Okay.
Madam Mayor?
Yep.
So I don't have to walk back to say this. If additional time is needed, your rules provide, this meeting had to be convened within 30 days, which means we needed to do it tonight. But you do have the ability, if you choose to do so, to continue this meeting to be sure that both groups have thoroughly thought about this. We're happy to provide this as a proposal in writing to them if they would like to take some time.
I don't want to take another minute on this. I just want us to move forward to resolution. What I'm hearing from the gentleman on this side of the room who spoke tonight is that we have identified a workable solution. And as long as we give you sufficient information with regard to what the meeting is about, who should attend, what's going to be covered, where it's going to be, you're going to be okay with that, is kind of what I've heard everybody say. You guys need to talk about that for a minute? Do you want to step outside, or? Okay. I mean, guys, we got to get past this, and talking about it for more time, I'm just not sure.
Absolutely.
How that helps us.
And what you brought up, Madam Mayor, is very important to us, but I don't believe that was the main intent or purpose to our meeting, the planning of the meetings and such and forth. One of my counterparts outlined Section 9 on unit modification of the rules and regulations of employer and employee relations, where it clearly states modifications of established appropriate units may be considered by ERO only during the open
Okay,
period.
and I'm gonna go back on this, and, because I think in my mind, that open period doesn't apply in this particular situation.
Okay.
Because we did not, we as a city did not get official notification that that was even gonna happen until April. So this is outside the norm of what occurred. They basically went through a divorce with the Teamster, not within the timeline, not with their own planning, to say, they didn't think about it for a whole year and say, okay, this is our window of opportunity. So,
And that is completely understandable. It's
Okay.
basically something that's not planned for. You don't know that it's going to happen, and it happens. So nobody can be prepared for the unprepared, basically. And we can see that. One of our issues when on September 4th is, here, you're together now, is these guys have been fighting a battle to be recognized as operators for years.
right,
And you guys are well aware of that.
yes.
And we're told, okay, now you guys are together, but there's no framework. There's nothing that shows how this is gonna work. So I know Mr. Ritchie's not here to elaborate or deny or say, yes, he said it, but basically, you know, he's telling those guys, hey, well, yeah, we're gonna be together but not together type issue. And we just don't understand how that could work.
Okay.
Because
So,
how can we bargain in the same unit, but we're separate groups? And I think that's one concern for everybody in our group, and that was the concern back then. If we would have been informed about this, because it clearly states that in March 7th, they already said, okay, we're cool with joining the wastewater. They could have told us, and we would have been glad to work, frame something out, figure out how it's gonna work, because Mr. Rich, he kept bringing up the word rushed. We don't wanna rush things. Things have always been rushed in the past. And I even said it on record, I said, well, this feels rushed right now. You're putting us together with no framework, no background.
Right.
I mean, they weren't even aware of that meeting where we were gonna be put together, basically.
okay,
So,
and
if anything,
if I had a magic wand, if you had a magic wand, if they had a magic wand, coulda, woulda, shoulda, there's probably a lot of things between March and now that we would have done differently, right? But we can't change that. We can learn lessons, and I think where we want to go is kind of forward from there.
and we understand that, and we're okay with that. We want that too,
Okay.
believe me. The only thing is that I believe that there has to be some framework. We can't just say, yes, let's do it.
Okay,
We
so,
gotta see how it's gonna work out.
okay, so, to that end, how is that framework going to be established?
Well, bearing in mind the council's request to go forward, that was why I suggested it was possible to continue this. The ARO and I have talked about this, and we would be happy to meet and try to outline a framework, meet and confer, and outline a framework that was acceptable to them with their input. I think that would be true of both sides. I think we
Okay.
Madam Mayor.
all agree that if we had it to do over with their comments, we would do it differently, but again,
Absolutely.
Madam Mayor, can I ask a few questions? So, Betsy, the comments that were made earlier and the letters that were shown to us from previous years in which modifications were made, in which the bargaining unit was notified via letter, and they were basically asked for their input on this, kind of makes it sound that the incoming unit has the authority to say yes or no. Yes, we'll take them, or no, we won't take them, right? And it didn't seem to me that that's the case. I thought that the sole authority on the placement of the bargaining unit risks with the city manager.
correct. However, the receiving unit does have the ability, first of all, in section 11, which we've talked about now a lot, the decision is one where you have to meet and consult. And the effort that the ERO has made here was to meet and consult. Whether, that didn't work and the way that was intended apparently, but that remains the objective. You meet and consult, and if you can't reach agreement, then they have the right to file an appeal, as they did. They have the right to appeal process, which they did. They have the right to appeal unit determination, which they did not. They have the right, if the decision goes against them in front of the council, to bring a writ in Superior Court. And the court could then go back and instruct the ERO in certain ways. But you are correct, the final decision remains that of the ERO.
Okay. And I thought that in our backup information, we have a letter that was written by our city manager, and I don't know if it was addressed to both groups or
Is that
one or
the
the other.
September 4th letter?
Well, it's the letter that kind of goes point by point
Yes.
over the findings that she made that concluded that there was a community of interest,
Yes.
and therefore the placement of the distribution unit will be appropriate within the treatment unit.
And those are the September 4th letter. We worked on these letters for quite some time to document why we believe there was a community of interest based on input from the Human Resources Director, from Mr. Campos, Public Works Director, from the job descriptions. And there were 2 letters written. One was for the underground group and one was for the Certified Water and Wastewater Treatment Operators Group to explain why there was a community of interest and why the ERO had reached that decision.
So let me kind of play hypothetical. So let's assume that the process as being requested by the treatment operator unit was followed, and a letter soliciting input from them was requested, some feedback, and that they came back and said, no, we don't agree. We are not accepting of this new group come to us. They would have had a right to appeal that to the council, right, ultimately?
There would have been an interim step. The interim step would have been a letter like the September 4th letter.
And then, okay, so that step takes place, it comes back to the council.
Right.
And then the council would either ratify the decision of our city manager or not.
Yes and no, and hold on. Can you put the PowerPoint back up? So here's your choices. One choice is to try to work it out always, continuation or no continuation. The other choice is to deny the appeal, at which point a time frame begins to run to go to Superior Court. The other choice, and we can go to the end, I can't number the slide, but it talks about toward the end. Okay, so keep going. The other choice is to uphold their appeal. Their appeal is a process appeal. It's not a
Right.
substance appeal.
Right.
So what you would basically say is, ERO, go back, start over, do it again. Give them a letter, solicit their input, they come to the meeting or don't. They come to the meeting, you tell them this is your intention, they say they don't like it, you write them the September 4th letter again, and then they can appeal again.
So,
You can go round and round for quite a while, I'm afraid.
So in that hypothetical scenario, let's say that hypothetically we would ask to go back and redo it, how long is that process?
I'd say a month or, yeah, 2 weeks to a month at the least.
So it's pretty quick, it's a pretty quick process.
It's relatively quick.
Okay. So, let's see if I had, so can I ask you a question? So on your letter, on your appeal letter, you said that you would like the council to invalidate and set aside the decision by our city manager. What does that mean? Because I think it may have a legal definition, and I'll defer to our lawyer friends to confirm that. But what does that mean to you?
Just to keep our regular bargaining unit intact and continue on negotiations.
Okay, is that what this means?
That's what I believe they meant. However, that isn't what you would get. What you would get is to go back and repeat the process without a change in the unit determination.
Okay.
And if the council wants the RO to do that, let me suggest that without ruling on the appeal, you continue this hearing and ask her to do that, which she will be happy to do. But it will leave you, I think, in the month at the same place with no bargaining having occurred.
Right. Yeah.
Because ultimately, we've already found the, what's the term?
Community of interest.
Shared
interest.
community of interest.
So I think both groups have agreed that there is that. So based on that, then we would come right back to where we are today.
Yeah. Well, because, if I may, I think that there's a legitimate point that was made by the treatment operator unit in that the process that we have was not followed to the letter. I think that we recognize that. A written notice was not provided prior to the decision being made. And I gather from the comment that was made earlier that the process also would have required, after the written notice is submitted, a meeting with all, how many units in your, how many members in your unit?
Roughly 20, more or less?
Okay. That a meeting would have been called for all, with all 20 people to show up and say, so what do you think, right? And that's, and neither, I mean, the reality is, from my perspective, is that neither of those two things really happened. I'm not sure, given everything else and all the efforts that were made to communicate, if that's really a material fact that should weigh us to rule in favor of the treatment operator unit. I'm not sure about that, but I think that we should recognize that didn't happen.
In the interest of the record, I don't think either of those is completely accurate. I believe that there was a letter given and a meeting held. That was a September 4th letter. I
Right.
think what they're saying is they didn't feel they were heard appropriately, and that there was, from what I heard, confusion. And I believe that the meeting isn't of both units of the unit, it's of the unit representative. They obviously have the responsibility to meet with their unit as a whole to discuss this, but the ERO isn't required to do that.
If I may add, the September 4th meeting was basically, this is what's gonna happen. You guys join the 9 members. They never mentioned an appeal process. They always referred to an impasse, and that's stated on the letter that she rewrote to us after we respectfully asked her to rescind that letter that she made on September 4th. It was always about going to impasse. And we don't understand why are we gonna go to impasse? Why are we going to impasse? We had no idea about an appeal until we ran into this resolution 0271, that you only have 10 days to appeal. And by the time we figured that out, we're already halfway through the 10 days. We had no time to meet and confer about resolving this issue. I just wanted to point that out.
But may I ask you, so on the, on September 11th letter from our city attorney, city manager back to you, responding to your September 10th, I hope I'll get the dates right. She did leave the window open to go back and still keep talking about that, and you guys chose not to do that.
Yeah, because we were in the process of just studying this resolution, and we only had, when we figured out we only have 10 days to respond or to make an appeal, we were out of time. We barely had enough time to make this letter, and we actually appealed the last day of that letter. So there was really no time to actually meet and confer about this, because it was just we were gonna bypass those 10 days, which would have made this meeting impossible.
One small point. If you look at the September 4th letter, it does say in the last paragraph that if,
Can you give us a page citation, please?
yes, ma'am, on my pages, it's packet pages 23 through 25. Nope, 24th, 22 through 25.
And you're referencing the letter dated what?
September 4th to,
To Miguel, or?
no, to their group, I'm sorry. Go to packet page 20. No, 20.
That's page
Oh,
17 for
17,
us.
I have a different packet.
Page 17 for us.
Right.
Got it.
Okay. This letter attempted to do two things. It attempted to follow up on a conversation which Mr. Ritchie had with them, according to what he told me, regarding how to deal with a situation if they were together in the same unit and their bargaining concerns could not be addressed because of differences between the two groups of the unit. It does, in fact, refer to sections 9, 11, and 12 of the Employer Relations Resolution, which would include the appeal procedures. If in fact there was confusion about the letter, I was not present at the September 4th meeting, then in fact those 2 points were not clarified.
All right, so, silver lining in all this, I think that we figured out some ways that we could have done this a lot better. So if there's an opportunity for improvement, we've certainly discovered what that is. I kind of agree with my colleagues. I think that if we were to grant the appeal and just start this process over, we're going to end up exactly the same place we are now, just a month or 6 months or something down the road. And couldn't that time be more constructively used to bargaining separate but equal, and then coming back together and figuring out where that shared community of interest is, and then moving it forward? But, yeah, let me finish if you would. The council has identified early on that one of the goals of this entire bargaining process, going all the way back to the springtime when we announced that we were bringing in new folks to do the bargaining, is that we were going to collectively take a look at all of the bargaining units and figuring out what kind of cleanup is needed within the MOUs, as well as determining if everybody is appropriately placed and what more modifications could perhaps come forward during this process. So I think that we are still very much in that mode where we'd like to move forward, and what I thought we had was agreement to do that. So, and there could be tweaks between now and whenever, but it's kind of where we're at. That's Mr. Salas, is that right? Okay.
Okay, we didn't want to stop the process. We want to work with the city. We are team players. We work together. But what really bothered us in the process is the way that it was take it or follow it.
Right.
Now, we were told by Mr. Rishi, unfortunately, Mr. Rishi is no longer with the city, but we were told by Mr. Rishi that we will get something in writing before meet with the underground people, us, and the city group. We never got that information, that package. So when we received the letter, in which, by the way, I was absent because the subject was a mandatory. That was a Monday. I was working, and I told Marco, you know what, I'm going to be there, but it's going to be a labor negotiation, so we can go forward, you can do it. Suddenly, we received that information. So this is what is happening right now. Underground people is part of your group. So
Okay, so I'm going to ask you one thing. Tell me something that we haven't heard yet tonight.
what I'm trying to say is, right now, you are saying, okay, we can work it out, we can probably do it, but at least we will have to have something in order to go forward or move forward. That's the only thing we are
Right,
requesting.
and
And
I-
obviously, I would,
And I think we've agreed that we're going to talk about framework, and the city manager and city attorney have both agreed that prior to the next meeting, we're going to talk about, this is what it's going to look like. This is what we're going to talk about. These are the issues.
that's the only thing we are asking for.
And I think we've
And-
agreed to that, right?
May I ask a question, Madam Mayor?
Certainly.
Mr. Salas, what do you mean by we have to have something? Do you mean a written document, or do you mean
Yeah,
consideration?
something in writing, because when you're stated, okay, we
Understood,
will
okay.
be two different bargaining units
We agree.
working on the same, with the same document. Sometimes it's hard to deal with because it's just because differences in.
We agree, and we agree it would also benefit the city to have that document, and I think it's a good request.
And it'll be shared with both groups.
So that's the only
And
thing
if any clarity needs to be done, let's make sure that there's open communication so that everybody's working from the same rule book, okay?
So
Okay.
that's the only thing we're
Okay,
looking
I
for.
think we addressed that one,
I think we're
I
good.
hope.
Okay,
Okay?
thank you very much.
Madam Mayor, to be sure.
Okay, because if this is something we've already heard
No,
before.
you have not, because
Okay, we're ready.
we keep hearing that we were given a letter stating the intent. Well, this is the letter of intent that the water plant received back in March 31st, right on the deadline apparently. And it reads, in according with resolution number
That's 2011, right?
0271,
That's from
2011,
2011.
the city may propose during the open period to modify a bargaining unit. The proposed modification is requesting to add the four gentlemen from the underground crew. So there's a history of, this has been done before.
Right, three
And it-
times.
And
We've
it
looked at
clearly
that.
states that the city can do it during the proposed time. It doesn't say that the city can do it or the ERO can do it at their bidding. It clearly states here the time before, and it was done in that fashion. So if you go through the
Madam Mayor,
packet, you
if
will
I
not
can
find a
address this.
letter. You will
We-
not find a letter like this in our packet.
We understand that, and we've addressed this many times already. Basically, we said, yes, there are rules and regulations for when you have to comply with the rules and regulations that we stated. However, this was a unique situation where we clearly cannot travel back in time in order to give you notice of something that we did not know was going to occur. If the event that created the ripple effect of this entire situation happened in April, how can we give you notice in March?
So can I ask you this on record as a lawyer? Could you use that in court?
Absolutely.
Could you do that?
Yes,
Can you say I can't go back in
There
time?
are exemptions
You just said you can't go
to
back on
rules.
time.
There are exemptions
Can you show
to
me where the
rules.
exemptions to the rules are written? Can you show me where it's written that you can exempt the rules? Because it
Yes,
clearly states
I
here.
can. Yes, I can. And
So,
if you would turn to page.
I'm a little
I'm
con-
going to use the
Can we-
resolution.
Can we spend about 5 more seconds on what I consider to be a really unproductive
Well,
situation
we don't feel
here?
it's unproductive because the word keeps get throwing out that we received a letter. The only letter we received was, you're together.
okay.
And in the past, they have
Okay.
asked the operators,
Absolutely, and I think that we've acknowledged that, and I think that it
Madam Mayor,
was,
just so that maybe so that people can understand my own rationale as it relates to Section 11 and the March deadline, because I did not believe that the March deadline applied in these circumstances for my own interpretation of what I read. And I'm not a lawyer, so I rely on the lawyers to tell me that I was off or not. But if I can refer the council to page 51, which shows you Section 11. Right. When I read this, and I went through, I want you guys, I read everything in this packet more than once, because I took this responsibility really seriously. It's not something that I took lightly. So it says, the employee relations officer may, on her own motion, propose during the period specified in Section 7 of this article that an established unit be modified. So when I read that, I thought, okay, yeah, they're right. This should have been done in March. But then you read the next sentence after that, and it says, the employee relations officer may, at the request of any employee or group of employees, or by her own motion, propose that an established unit be modified. So to me, the restriction on the March related to the first sentence of that paragraph, which is when the ERO does it through her own initiative, and that the second sentence, which addresses when an employee group petitions that March deadline did not apply under that circumstance, that the restriction on the timeline only applied within the first sentence of that and not the second sentence. That's how I read it.
You could be a lawyer, Councilmember Silva. That was meant as a compliment.
Thank you. I don't know if it is
you
a
don't
lawyer or
need
not.
to take it that way, though.
So that's why, from my own perspective, I rejected the notion that the March deadline applied. And again, I think I think that we need to concede that the rest of the process was not followed to the letter. Because the September 4th letter was not a letter announcing a proposed action. It was announcing a final action, which was to separate, to incorporate the unit. So I get that, right? But I'll be honest with you guys. If I agree with the action and the analysis that was made by our city manager that led her to conclude that that is the right action to take, to incorporate the two. I do believe that she analyzed it well and that her rationale is sufficient for me to accept that as a proper action, right? So if the only remedy is to go back, do it again, and then come back to me and say, well, we don't like it, my answer is gonna be, I'll support her action because I think it was done under a legitimate analysis of this. So rather than waste time on all that, I think that we should use the time productively, move forward with negotiations, allow some discussions to take place, understanding that ultimately I am going to support that action that is being proposed. So that's kind of where I stand.
And I do want to address your point. I think that, and it was brought up earlier, under the best-case scenario, would have you been notified, like, as soon as it became official? Here's a list of folks that have been asked to join your unit. Absolutely. But I can probably point to 5 or 6 other things during this entire process that I wish we could hit that do-over button for. But again, I absolutely agree with Mr. Silva, and I think that he stated it very eloquently. If all we're going to do is jump back on that hamster wheel, spin for a little bit, and then come back here, why would we do that? Isn't our time better spent moving forward with establishing what that framework's going to look like and moving forward with the bargaining and getting back to work? I'm thinking. Comments from other council members before we look for a decision?
I concur. I think, both parties have demonstrated that there is that community. I think that we would come back and we'd be right back where we are today if we upheld the appeal. You guys say you want to be team players and that you want to get this moving forward and you want to bargain and you haven't really had the right or the opportunity to bargain. I think that's unfortunate. I think, when we're about to sign, everybody else is almost done and you guys are still at the starting line. I think that's unfortunate that this happened this way, but I think we got to move forward. And I think for the benefit of your employees that you represent and the employees that they're representing, I say we just get this done. We let the city staff come up with a framework that's acceptable to both groups, and you guys get together and you bargain and we get this done. And that's kind of where I'm at. I hope that you guys feel the same way because I think ultimately we all want the same thing to get this thing done for everybody.
Mr. Cardenas?
I missed some of the fireworks, but I wanted to just provide a compliment to you, sir. I appreciate when you first came up and said, hey, this isn't a situation where we don't want them, and you also acknowledged that, hey, this is our first time us coming before the council, and I want to just compliment you guys on your efforts in coming before the council and being heard. It takes a lot of courage, takes a lot of organization to come up here, and I do appreciate the efforts of our council and listening and really trying to provide an explanation on how we got to this point. So I do, first and foremost want to provide you guys a compliment and appreciate your organized effort. I also want to say that our city manager, along with our legal team, has been looking at this situation. They have been keeping us up to date. A lot of information has been shared, and so I do also want to recognize the efforts of our legal team or our attorneys and also staff, in particular, Ms. Piedra. And so, and I think the overall goal, again, is to start bargaining, get to some sort of agreement, put this negotiation behind us, and not have to worry about this for the next 3.5 years. So I am in agreement with our colleagues, and I do appreciate Mr. Silva's leadership on this issue and the way he explained that. So I'm also going to be in support of our colleagues' efforts, but do appreciate your organized effort and you guys coming here tonight to be heard.
Did you have anything?
Just briefly, I didn't mean my comments to be disrespectful or confrontational in any way, but I just think that in the end, if we set this aside, we're just going to find ourselves here in a month or two, going through the same exact process. And I don't think anybody wants to find themselves in that situation. It's just going to cost everybody more time and effort, and we're going to be spinning our wheels with procedure when we can concede that things could have been done differently. But ultimately, what is the goal? The goal is to get a nice agreement done between your unit and the city. And you're going to have the opportunity to be heard. That I completely want you to have. You need to have your own concerns, your own unit essentially expressing what is going to benefit your members. And what we're saying right now is if you have differences in terms of what you prioritize, those are going to be completely heard. And it's going to be part of the bargaining process. But because of the similarities between your units, we would find ourselves not negotiating in a week or two, but in a month or two. And I don't think that's going to benefit anyone. So we want you to be heard. And of course, if this situation doesn't need to occur, then we will do everything we can to make sure that you have the proper notice, that you understand the complete framework of what we're trying to do, and that you're informed, ultimately. Because everybody deserves to be informed and part of the process. That's why we have this transparent form of government, and that's why we bring everyone to the table. So I hope that we can continue with these negotiations and hopefully come to a resolution that benefits everyone, because you are the city. You are us. We're not confrontational. We're all part of the same family here. We're trying to reach agreements so everyone can go forward and our beloved city can prosper.
Okay. I'm going to say one thing that I don't think has been said before. It's probably the first thing we should have said. We value the job that you guys do every day. And we know that the work that you do is instrumental to the quality of life that we promise to our residents of the city of El Centro. So I hope that each and every one of you understand that we value your service to the city of El Centro. We hope now that we can move this process forward. Thank you for being here. We have a,
So, Madam Mayor,
Yes.
so in terms of an action that accomplishes the desire of the council,
I think the
Betsy,
motion
what's-
would be to deny the appeal and to give direction to staff with regard to the initiation of bargaining discussions with the two units.
Bearing in mind the comments they have made about requirements for written procedure.
Go with that.
And Madam Mayor, is there a motion on the?
That's how I'm framing,
Oh, okay.
if somebody wants to pick that up as their own.
Well, I just wanted to, and I apologize for stepping out, but the request in regards to the separation of the two groups in negotiation, did we talk about that? or-
Yes, and both groups agreed that they were fine and dandy with that. Well, maybe not dandy, but they were certainly fine with the concept of moving forward with
As long as it's in
separate,
a written format.
Okay.
separate, and then
Yes.
under the umbrella.
Okay.
So we have a motion by Mr. Jackson, we have a second by Mr. Silva, and that passes 5-0.
And Madam Mayor, I always get to be the spoiler. I need to tell you this, and you need to tell me if you understand what I'm saying. You have 60 to 90 days, depending on how this hearing is characterized, to file a writ, either a, what's called a 1085 writ or a 1091.5 writ, 1094.5 writ in the Superior Court in Imperial County. Be sure that you understand those timeframes. Be sure that you seek legal help if you need it for those. It is my job to make that clear to you, not to encourage you to do it, but to be, so is that, have I communicated? Thank you.